afternoon, everyone. Thank you so much for joining us today for Compliance 101. I wanted to begin with a couple housekeeping items. First of all, you all know how to ask a question, and that would be to type it in on the right-hand side panel of your screen. You can type those in at any point of the webinar, and Mike will answer them at the end. Just a reminder, it takes 7 to 10 business days for your credit to appear on your portal, and you will also get a credit mailed to you. I wanted to take the time to quickly review how you receive your credit, and most of you are great about this, but I know there's been a lot of questions as of recent, especially as we get close to the end of the biennium. So the first thing you're going to have to do is log into your NYS FDA portal and register for the class. And I have a slide up here that shows you what you will see when you log into your portal. Now, this could be done individually or one person. It would have to be the primary person at your firm could go in and register everyone at once. Very simple process. You click on the events that you're looking to register for, one at a time, click it, go in, register yourself. At that time, you will get an email, and in that email will be the link to the GoToWebinar, which is the platform we use for our webinars. I usually recommend about 15-20 minutes before the webinar starts, you click that link. It's going to bring you to this screen. And you're going to put your first name, whoever the point person is. Now, I know some of you have one person sitting around a computer, and some of you have 10. So one person puts their first name in, their last name in, and their email address. Funeral home name, the funeral home city. And then you're going to want to count how many people are sitting around you and put that number in here. And then list each funeral director that is sitting in around you. GoToWebinar provides us with a report at the end of the webinar as to who was sitting in on this webinar and how long you were in there for. Both steps must be completed for each person, or you will not receive credit. So I need to see your name as pre-signed up for this webinar through your portal, and then I need to see your name come across this webinar report, either as the main person who signed in or one of the additional funeral directors. Keep in mind, if you drop it all during the call or have any problems, please call us immediately or send us an email. Most of you can get right back on, and that's absolutely fine. But if you're having problems, please don't wait. Please give us a call or send us an email, and we can help you. I will be monitoring my emails during the webinar. It's kelly@nysfda.org. So thank you all. And at this time, Mike, are you on? Oh, we can't hear you, Mike, if you are on. Just give me one moment, everyone. Okay, Mike is having one computer problem. It's not a permanent problem. All of a sudden he got an update, and we all know how that happens. So just bear with me. It looks like, are you on now, Mike?
I'm in. Yep, I'm in. Sorry about that.
Perfect. Well, thank you so much, everyone, for your patience. And at this point, I'll turn it over to Mike.
Great. Thank you, Kelly. Good afternoon, everyone. Welcome to this afternoon's session. I'm sorry I was just a second late jumping on, so I don't know if Kelly already mentioned this in her introduction, but this has turned into one of our most highly attended sessions. We actually, for those of you who've done this before, you kind of know that a couple of years ago we tried a new format for our for this session and decided to do it in a question and answer format. So what we do is we look at questions that we've received for, I'm sorry, 1 second, I'm being instructed to change something. Sorry, 1 second. Oh boy. I don't know what. Oh, hold on 1 second, please. All right, sorry, one more technical problem that we've just corrected. As I was saying, we've switched to this. So what we do is we have questions that you guys give us during the course of the year. And we decided that the best thing to do is give you real answers to those real questions. So we started to gather these. We change them up every year. We add some new ones, but some of the scenarios may not be exactly what we heard in the past year, but a lot of the same questions with the same basic topic and answer is what we get. So you'll see some new ones in there. If you're someone who's been on this presentation before, you might recognize a couple of these. One other thing, just to let you know, what I'm going to do is I'm going to go through these questions. You'll see the question on the screen. I'll give you a couple of seconds to think about an answer, and then I will show you the answer and just read it for you, maybe add a couple of comments in there. And at the bottom of the screen, you will see a source. So I will let you know if this was an answer we received from the people at the Bureau of Funeral Directing, or maybe it was them, and there's a reference to a law or a regulation in New York State. So wherever possible, I've included the legal or regulatory or authority reference so that you have that with you. We have 61 slides and questions and answers to get through. So we broke it up into some categories. We're going to start with business operations. So now that I apparently have everything showing you the right slides, let's get moving. Our first question under the topic of business operations. Can a funeral home charge more for embalming tissue or organ donor remains? According to the Bureau of Funeral Directing, yes. If you would like to do that, you would put it under other preparation of remains and usually with the heading restoration. Second question, is it permissible to take selfies during funeral services? I can tell you that this question has come up several times over the past year. The answer is there is nothing in the law or regs on this. So the advice of the Bureau of Funeral Directing is that the family should make their wishes known with the funeral home. So if it's okay to do so, the family should say so. If the family does not feel this is appropriate, then the firm should post a sign or a notice that says no picture taking so that folks coming in are aware of the family's preferences. Can a funeral home offer airplane bottles of liquor as a favor, quote unquote, at a celebration of life if the bottles are passed out as people are leaving and guests will be instructed to remember the person once they are home? In this situation, the family would be purchasing and providing the bottles, but it's the funeral home employees who would be passing the bottles out. They are not allowed to do that. So the funeral home employees should not be passing the bottles out. They should not be provided they can be provided at the funeral home. However, it has to be made clear that they cannot be consumed on funeral home premises. And the references to that, it was an answer provided by the Bureau, but this goes back to the food and beverage law, and those are the sites that you see at the bottom. So this is a scenario that came up as a follow-up to a recent, I guess a couple months ago, in terms of recent informational webinar that the DMV provided as it relates to the new inspection requirements for certain limousines. So the scenario was many funeral homes use vehicles with dark windows for removals and transfers. It's our understanding that the DMV inspections have one permissible level. Is there an exemption or a concession for these funeral service vehicles that allows for greater darkness? If nothing currently exists, is it possible to seek an exemption or an amended standard for funeral service vehicles? We do know the health department wants the back windows darkened to obscure the person, but are not aware if this was ever communicated to them or part of an agreement with DMV and the health department. If an exemption does exist, does or can it extend to the side windows as well? So there's a lot packed in there. The answer is, it depends. What it depends on is the classification of the vehicle according to the FMVSS certification label. FMVSS stands for the Federal Motor Vehicle Safety Standards. So if the vehicle is classified as a passenger vehicle on the label, then all windows except the rear, most if it's equipped with dual outside mirrors, must allow at least 70% of light to transmit through glass. If it's classified as anything other than passenger car, then only the windshield and two windows to the immediate right and left of the driver need to allow 70% of the light to transmit. They admitted that this was very specific, a lot of information, so they obviously want to be helpful. So the DMV's technical service unit would be happy to answer any questions anybody ever had on this. And we left the number for you here, 518-474-5282, and then choose option 4. Many casket suppliers are imposing surcharges on funeral directors who purchase caskets and urns from them. While that surcharge cannot be passed along to the consumer as a surcharge, are there any instances where a funeral home can list the surcharge for merchandise as a cash advance? The answer to that is no. So unless the funeral director is going to call it a gratuity and the customer can decline to pay it, it's not a cash advance. Instead, it has to be on the GPL because it's part of the wholesale cost of whatever merchandise is being sold. So if you're going to do something like that, you have to change your GPL so that you are recovering the costs there. Does state law provide any tax exemptions for funeral service? It does. It depends on what you're purchasing and what you're selling. So goods and merchandise that you sell to a family at retail are exempt from the New York State sales tax. So anything you're selling that is a good and merchandise. Anything that is not tangible, so not physical in nature, are not exempt and are subject to sales tax. In addition, the funeral goods and merchandise that you purchase at wholesale, meaning you are not going to then turn around and sell it to a family, you're going to keep it for operations within the funeral home, that is subject to the sales tax. Next, can the funeral firm offer a price match guarantee in which a firm promises to match the GPL prices of a competitor? So this has been around for a while, but we always like to remind you guys of it because this was actually part of formal guidance in the form of a letter that the Bureau issued back in September of 2019. In that, they cite both federal and state law and regs that require the GPL to have prices for all funeral goods and services regularly offered. They also go on in that letter to say the prices should be static until updated or amended, at which time the GPL is provided with a date stamp so families are clear about which prices are applicable on that date. And when I say they cite both federal and state law and regs, I put those citations on the bottom for you. Can a funeral firm impose a late charge for past due monies owed? If so, is it subject to the usury rate of 16%? So the good news is, yes, you can impose late fees. So the thing to know about that, if you are going to do it, is you have to give notice to the consumer that a late charge would be imposed prior to it being charged to them. So you can't say to somebody, oh, it's been 30 days, you haven't paid, I'm going to add a X% surcharge or late fee on this now. You'd have to have it in your agreement up front so that consumers know when they're signing the agreement that if they don't pay on time or within a specific period of time, that they will be subject to a late charge. So is it subject to the 16% usury rate? New York has actually two ceilings or maximum limits that can be charged in terms of late fees. There's one, the 16%, which actually only applies to loans. So in this case, it would not be applicable. Instead, it's the criminal usury rate that applies, which is the higher rate of 25%. And if you wanted to break that out into a monthly late charge, that would mean a monthly late charge of about 2.08% per month. So you could charge, if you do it monthly, and that's how you tell the consumer, you can tell them that you'd have a 2% late charge for any late payments. Next, we have a scenario for you. A woman wants to rent out a random funeral home to have a memorial service for a friend. No body would be present, as the deceased was cremated a few months ago, and the body was taken care of by another funeral home. The service would not be approved by the family. Does the funeral director have any liability if he rents out the place? So, according to the Bureau, in this case, the funeral director has the same liability as they normally would for things like slip and fall. If the group wants to rent the facilities and hold a memorial service for a decedent that the funeral director didn't cremate, and there will be no body or cremains present, and the next of kin of the deceased didn't authorize it, then based on all of those circumstances, they are free to rent the facilities to whomever they want to. So there's no additional liability, just the same liability as renting your place for accidents that might occur or injuries. Next, are funeral homes allowed to store bodies for another unaffiliated funeral home in their storage facilities? You are. If you offer it and it's on your GPL and you can subcontract, if the firm offers it on their GPL and you subcontract to another firm that leases them the refrigeration space, there's no issue. We do have a note here that this is a different answer than we received from the previous director of the Bureau. So this answer was provided by the current director of the Bureau of Funeral Directing. This is not in writing anywhere. This was an opinion or a position that was different from the previous director. So this is not relatively new anymore since Tom's been there almost 8 years, but this is the current position of the Bureau. Can a funeral director legally remove a pacemaker from a decedent? And if they can, are you allowed to charge for it? This is the long answer for you. So if the pacemaker is coming out for a cremation, definitely yes. Otherwise, it could be considered mutilation of a corpse. The family should sign off on the DOS 1898 giving their consent, and the pacemaker should be returned to the manufacturer to be decommissioned. If the removal of the pacemaker is on the current GPL, you can charge for it under preparation of remains and then explain in writing at the end of the itemization as necessary due to the family's selection of cremation. This is not covered in the public health law. It is in by the Division of Cemeteries because they require removal of the pacemaker on the authorization form. One note that I don't have on the slide that I want to be sure you're all aware of. So I guess it would be the past year or so. Many of you have experienced remains with the new Micra, M-I-C-R-A pacemaker that would require breaking the ribs to remove. The pacemaker is actually smaller, and according to the manufacturer, who is Medtronic, it poses no threat to crematories and should not be removed. They say it is 93% smaller than a conventional pacemaker and leadless. The Division of Cemeteries has not taken a formal position on this, even though we asked them about it. But to our knowledge, they have not and are not planning to go after anyone who doesn't remove the pacemaker. It's our understanding that many firms, funeral directors, have not removed these pacemakers, and to our knowledge, there has not been any issue with cremations. All right. Next, can a funeral home in New York State charge an extra $250 to make a removal after 5 p.m.? Another long answer for you. You are not. The short answer is no, and the explanation is that under the regs, specifically 78.4E2, it says that the price for a transfer includes personnel, equipment, and vehicle. There's no provision for differences in when people happen to die. Additionally, such a charge would be open to abuse by the funeral firm, since often the body can be left in the morgue until the funeral home decides to get it, handing themselves an additional $250 to pad the bill. In addition, the price of removal must be included in the price of direct cremation and direct burial, as well as the price for phoning remains and receiving remains. So if the price varies, then the argument is the price of these items would make the GPL pointless. The only qualifying language is when it comes to a transfer on additional mileage beyond a specific distance, whether that's a flat fee or priced by zone. For anybody who was at convention a couple of years ago, you also know that this was discussed as a guidance letter came out from the Bureau, and this is very consistent with that letter that came out. What rights does a funeral director have when they are in possession of remains and the family refuses to move forward? In that case, the funeral director should give the family a deadline, at which point you declare the body abandoned, and if they have not given you a decision, you turn the body over to the county medical examiner for disposal or disposition. At that point, if you go to have to do that, you are authorized and allowed to bill whoever gave you that permission for the transfer of remains for services rendered to that point. Okay, another scenario for you. A person dies in the Mount Sinai South Nassau off-campus ER in Long Beach, and they hire an ambulance service to transfer the deceased from there to the South Nassau Hospital in Oceanside. The deceased have been pronounced at the first hospital. Does this act violate the rule or the law that nobody except a funeral director, ME, or coroner can legally transfer the remains? So this answer will depend. So if these, the reason I left the hospital's names in there is because if the institutions are under the same umbrella, which if I remember, they were, so these are all basic campuses, so to speak, of the same institution, then the body, if it has not been released by the family, if the hospital can then move it within the same umbrella family of institutions or locations as much as they like. Apparently, this was a question, I know this question was asked post-COVID or very soon after the first COVID wave or end of COVID. Apparently, this was a very common occurrence during COVID, and what Tom told us was that it was always that way, but rarely necessary until morgue space got scarce. So this is a question that had come up frequently 2020, 2021 timeframe. Does New York require that certain funeral home support staff be paid at specific intervals? It actually does. Labor law, New York labor law, section 191 is the section. It does require that companies employing what's called manual workers pay those people every week. The definition of a manual worker includes workers who spend at least 25% of their time engaging in physical labor, which includes common tasks like sweeping, carrying, and standing for long periods of time. So we know that there are staff in funeral homes who clearly would meet the 25% threshold. In those instances, you have to pay your employee every week. This was a law, or is a law, that has been around for an extremely long time. It had never been interpreted this way, but then in 2019, this went to trial up to the appellate courts in New York, and the ruling at the appellate court was that if you pay your manual workers less frequently than weekly, it's triggering damages. So the irony is that you have paid your employee exactly what they are entitled to. You might have done it every, say, bi-weekly instead of weekly. But because you didn't pay them every week, you are subject to damages for not paying them on a weekly basis. So again, it's important for you to know that if you have employees who are deemed manual workers, they need to be paid on a weekly basis. All right, so that covers the funeral home business operations section. We have a couple of questions in pre-need, which are tried and true repeat customers on a regular basis. So we'll go through those for you. When should a person establish an irrevocable pre-need account? Okay, so under the law, if you are an applicant or a recipient of Medicaid or SSSI, then you would need to establish that account as an irrevocable account. That's to ensure, as part of that spend down, that those funds are not counted against your income when you're trying to determine your Medicaid or SSI eligibility. So, as you probably all know by now, since this is 13 years old, the law also allows for that recipient or applicant to also open pre-need agreements for family members. They now must also be irrevocable. So that's just an important thing to know, that if it's part of your spend down and the recipient or applicant is going to try to spend down more, that they can open those up for family members, but they would also have to be irrevocable accounts. And as I'm sure most of you all know, that although you can't, they're not revocable or refundable, then you can't withdraw those accounts. You can actually move them and transfer them between funeral homes. I have a note at the bottom, which is also important to note, because we have run into this in the past. A person may only have one pre-need account. If you are, and this is only applicable to legally to irrevocable accounts, because it's under the Medicaid law, not the general business law, where it says you can only have one account. So could somebody potentially have two revocable pre-need accounts set up at two different funeral homes? Yes. We don't encourage that for a lot of reasons, but legally it's not impermissible. So I just said you can open up for family members. So who is considered a family member when you're doing this? So the general business law does define family member for this purpose, and it includes a spouse, a both minor and adult children, including adoptive and stepchildren, siblings, parents, adoptive parents, and the spouses of those individuals, as long as they are still married and considered spouses. All right, so now you have an irrevocable account. The person dies and there's money left over. It's known as the overage. So if that is the case, who receives the overage? Under the general business law, again, any overage that is remaining after all the selected funeral services and merchandise have been paid for must be forwarded directly to the DSS office in the county where the beneficiary resided at the time of death. So a common question we get that's related to this is, okay, well, if you're going to have to give the money to DSS, can you use the overage that you see is going to be there instead to add additional services or merchandise? Again, the law covers that. No, you are not allowed to do that. So as with any irrevocable pre-need funeral arrangement, including the ones for family members, after the originally agreed upon funeral services and merchandise have been provided, the remaining amount must be sent over to the DSS office. So you are not entitled to use those funds to add additional services or merchandise. So related to this, there's a question we're asked is whether you can make changes to an irrevocable agreement. So yes, you can have changes to an irrevocable under certain conditions. One, it has to be the purchaser that's making the changes, and two, the changes must be made pre-need. If it's an irrevocable agreement, any changes must be of equal or lesser value. So again, if you've made decisions, you've put money aside, and now you want to make changes, even if it's pre-need, you can't add things that are more expensive. You can make changes of equal or lesser value. The only person that can make those changes is the purchaser. Can a funeral home or funeral director be designated as the beneficiary of a life insurance policy? No, unfortunately, you are not entitled under the insurance law from being designated as the beneficiary. However, you can note that a policy can be assigned to a funeral home after the policy holder's death. So again, you can't be named as the beneficiary when it's being set up. After the individual dies, the beneficiary could decide to assign it to the funeral home to cover the expenses of the person's services. All right, so that wraps up the pre-need section. I'm going to move over to final disposition now. Excuse me. Can the funeral director serve as the agent for a friend who has no family? Yes. Funeral director is totally entitled to serve as the agent. However, under the law, it's very clear that you cannot be compensated or receive any type of financial benefit if you serve as the agent. One thing you can always do, and it doesn't impact if you're getting compensated or not, is you can serve as a witness on the agent form. So you can serve as one of the two witnesses. Do foster parents have the right to control disposition of a foster child who passed away? So if you are the foster parent, you do not have the rights to control disposition. If your foster parenthood turns into being an adoptive parent, so you've now illegally adopted the child, that puts you number 4 on the hierarchy list under the final disposition law, and you would then be entitled, so that, assuming that there's nobody above you in 1, 2, or 3. The other way it could happen as a foster parent is if you are then subsequently appointed legal guardian by a court, which puts you number 6 on the list. And again, as long as you are the highest person on the list at that time, you would have the right to control disposition. Similar circumstances, if a biological daughter of the decedent was adopted by another family before the decedent's death, is she still considered a child for purposes of the priority list? Okay, so in this case, once you are legally adopted, the adoptive parents are your parents. And all the rights of a parent are moved over and transferred over to the adoptive parents. So once you are adopted, biological parents no longer have any say in terms of the final disposition law. It's the adoptive parents who control. As in the case, I put this here because this was what Tom said. If there's any challenge in who's claiming to be the parents and thus control, then they need to go to court. And that's kind of common practice or common answer from us here at the association as well. We know what the law says, but if there's ever a gray area or you're in the midst of a heated argument and no one can prove to you anything definitive, we always say to take pause and have a court direct you on what to do. Are stepchildren considered children when it comes to the final disposition law? You are not considered a child under the final disposition law. And the reason is that there is no legally recognized relationship with a stepchild. The stepchildren are not, under the law, heirs or descendants. That relationship is only created, again, if the child winds up being adopted. So unless the stepchild becomes the adoptive child of the decedent, they are not children under the final disposition law. If a child is accused but not charged with the killing of a parent, do they need to sign this cremation authorization form? They do not need to sign it. We have another question that comes up a lot that's kind of related, is whether this person has the right to control disposition. So under Public Health Law 4201, that final disposition law that all these questions fall under, unless the person is charged or arrested in connection with the death, they can still serve as the person in control. So in this case, the child is accused but not charged, and therefore could still control disposition. Okay, a little scenario for you. An under 18-year-old mother an under 18-year-old mother's child dies. Does the mother have the right to control disposition, or is the fact that she's under 18 preventing her from doing so? Again, we have to go to the law. There are not a lot of definitions in the public health law related to 4201, but they do define the term person, and is defined as a natural person 18 years of age or older. And then that's the first section of the law. Then you get into the specifics about the priority list, and that section starts with the following, or the following language. The following persons, you can see I italicized and underlined it there, in descending priority shall have the right to control disposition. So the people listed after that sentence are the ones who have control. A person is someone who has to be 18 years or older. So in this case, even though she's the mom, she's not 18 and not deemed a legal person in the eyes of the law, and therefore cannot control disposition. All right, switching, final disposition still, but switching away from child-based questions. If a couple is separated but not divorced, is the surviving spouse still the next of kin? They are. They remain spouses until they are legally divorced. So just so you know, a legal separation, what that is, it's actually a court order. It's usually accompanied by what's called a separation agreement. And the separation agreement deals with division of property, setting arrangements and responsibilities for raising kids. It deals with any financial matters, like anything that you had jointly. It separates those and ends any financial connection between the spouses. But it does not legally end the marriage. So until you are divorced, you are still spouses for purposes of the final disposition law. Does a person need an attorney or notary public when filling out the agent designation form? You do not need a notary public or an attorney, but as I mentioned earlier, there's two witnesses, so you do need it to be witnessed by two people. Can an individual appointed as the agent also serve as one of the two witnesses on the agent designation form? Absolutely. There's nothing in the law that prohibits someone from acting as both the agent and a witness, so they can sign in both places. Can a person named power of attorney appoint themselves as the agent to control final disposition? This is a common question. Power of attorney questions we get all the time. And I bet you Kelly's smiling in her office right now as I say that. No, a power of attorney may not self-appoint. So a power of attorney, if you've been given full authority, by that I mean every matter related to the person. You can limit it to real estate transactions or financial transactions. So if it's an unlimited power of attorney or a full power of attorney, you can appoint somebody else to serve as agent, but you can't appoint yourself. And obviously, if there's any challenge that they think might come, they should be consulting their attorney. It's also important to note that a power of attorney ends at death. So once a person dies, that person whose power of attorney does not have the ability to control final disposition. We get that all the time. Well, I have a power of attorney here. That's nice, but that doesn't have anything to do with final disposition, because once the person dies, the power of attorney ceases to be the power of attorney. It only applies to the living. If a person completes the agent designation form in another state and or is a resident of another state, but is going to be using a New York funeral home and be cremated or buried in New York, is the agent form still valid and enforceable? It is. It doesn't matter where it's signed. It's still valid. Interestingly, as a footnote, if the decedent signed the New York form, but then they're going to a non-New York funeral home, that funeral home has no obligation to abide by our form. It's only applicable and enforceable against New York firms. Is the funeral director required to obtain documentation for proof of a domestic partnership? So as you know, domestic partners are pretty high up on the priority list. So the question comes up a lot about domestic partnership. So the quick and dirty answer is no. Black and white, no, you are not required to provide proof of a domestic partnership. So I'm going to give you my opinion here, which I try not to do too often on these issues, but I think it's important because I do tell anyone who calls me about this. So I feel it's very important for you to have a reasonable belief that a domestic partnership exists, especially if there's a potential for it being contested. So how can you prove, or what does it take to have that reasonable belief? So for that, I refer to the law that talks about the definition of a domestic partner. There's a couple of ways in New York you can actually have a domestic partnership. The easiest way to determine it is through either agreement. There's actually a domestic partnership agreement that you can sign, or you register as a domestic partner, which several of the localities have the ability to do that. They actually have registers for domestic partners. The other ways are you're officially named as a beneficiary, like say in health insurance or the person's employment benefits. And the most common one that we come across is under what's called the totality of the circumstances test. So the totality of the circumstances test means you look at several different factors. None of them is determinative over than another. None of them weigh more heavily than the other. But you look at things to try to determine that they are living together and creating a single household unit. So they are not just roommates and living together that way. They're actually trying to create a single family household unit. How would you do that? You both signed on to a lease, or you're both on the mortgage and own the house together. You have joint accounts. You are both on any of the utility bills. You're sharing expenses. You have checking and savings accounts in common. You have children in common. And the length of how long you've been together. You've been doing this for 6 months. You've been doing this for 6 years. You've been doing this for 60 years. The more time you've been doing that together will have some influence. So, you can ask just for something. It's reasonable. You just want to protect yourself. Ultimately, if the person coming in claiming to be domestic partner is going to sign the at-need form saying there's no one above me, you are covered as long as you have a reasonable belief. It does not, the reason I say you should ask a couple of simple questions to see if you can get information is that it's not unreasonable for you to take that step. If you can find that information out with just asking a question, it's just further protection for you before moving forward. Next question, can the designated agent refuse to serve at the time of need? I bet you everybody knows the answer to this one. Yes, of course. If you are unwilling, unable, or not competent to serve, you go to the next person on the priority list. That's what the law says. So if you are unwilling, that's the same thing as refusing to serve. Okay, we have another scenario for you. Man dies who has been in a group home. It's a direct cremation. His mom is still alive, but in a nursing home with Alzheimer's. She has a significant other who is her power of attorney. There's also a living aunt and uncle who would be willing to sign. Who should sign the cremation authorization form? The aunt or the uncle should sign. So, she has a significant other who's her power of attorney. Significant other has no legally recognized relationship on the priority list. Power of attorney has no legally recognized relationship on the priority list. And as I mentioned, in this case, the significant other, it's her POA. When I said when she dies, the POA ends, so that's not even part of it. The significant other, unless they're the domestic partner, which in this case they weren't, they were just saying they were the significant other, does not have any type of relationship on the priority list. Therefore, you would go down to the aunt or uncle. Another scenario, an adult child who has no spouse and no children passes away and has been estranged from her parents since she was 12. She moved from another country to the U.S., even though her parents stayed in that country. Her brother is willing to sign the cremation authorization. However, her parents are reachable, but they don't speak English. Who should sign the cremation authorization form? So, you go down the list. Parents higher than sibling. Parents are reachable. So you should reach out to the parents because they are next in line. If those parents are willing to sign, great. If they don't want to, they could always waive their rights to have her brother sign. But the parents are the ones who the funeral director should go to first. All right, another scenario for you. A decedent has a brother and nieces as next of kin. The nieces tell the funeral director that their uncle, who is the decedent's brother, has disowned the family and either won't share or don't have any contact information for him. If the nieces say they don't have contact information and or aren't willing to share it, can the funeral director move down the priority list and work with the nieces? Or is there some other independent action the funeral director has to take to try to contact the brother before being able to say he was unavailable and moving down the list? So if again, the nieces are going to be signing that at need statement, if they're saying that the brother's not reasonably available, unwilling, or not competent, and they don't expect him to be in any of those situations where he could act as the agent in control, then the nieces can claim the right to disposition. So it's not, according to the Bureau, it's not the funeral director's job to determine what the status of the brother is. As I'm often told by Tom, you are not the detectives and the private investigators. If you have a written statement and you're acting in good faith, you have protection from liability under the law. All right, so now we're going to switch over to a new topic, which is a couple on death certificates. Who is entitled to a copy of the death certificate? So the list of people under 4174 of the Public Health Law includes spouse, children, siblings, parents, or lawful representative. Those are the people who are entitled to a copy. In addition, anybody who claims to have a legitimate need may apply or request a copy from the local registrar. When it's all said and done, if there's any question as to who is entitled to it or what the legitimate need is, if there is a legitimate need, does this person actually have it, that is something that the registrar or a court would be the one to determine. A mother lost her fetus at 14 weeks gestation while at a hospital. The hospital will only release the remains to a funeral director, even though the mom wanted to take the remains with her. The funeral director said, "We were previously advised that a fetus that has reached at least 13 weeks gestation will be issued a death certificate." So the question is the process of filing for and issuing a certificate in this scenario the same as the quote-unquote regular process? So according to the folks at Vital Records, regardless of the gestational age, a fetal death certificate is to be filed for the event. And you can see if it's over or under 20 weeks, you have the different answers there, if you have to be involved or not. So over 20 weeks you do, under 20 weeks you don't. If the disposition is taking place outside of the hospital, a funeral director may be needed to handle the disposition and obtain a burial transit permit. If the situation presented, this is the Bureau of Funeral Vital Records telling us, saying, I believe that without knowing the mother's intentions for the remains, that a funeral director is going to be needed to handle the disposition. But again, as you can see, no matter what the age is or how many weeks, you will be required to be involved if over 20 and maybe under 20. It's important to note, I think it was even as early as last year or the year before when we did this, that we were originally told or previously told that if you were under 13 weeks gestation, that there would be no death certificate issued. So this is a change in position by the Bureau of Vital Records. So now, no matter what the gestation period is, you should be reaching out to get a fetal death certificate. And again, whether you're involved or not depends on the length of time. Can an eye doctor sign a death certificate for someone who passes away at home? If the eye doctor is an ophthalmologist, meaning a medical doctor, yes. Otherwise, they cannot. So somebody like an optometrist would not be entitled to. So here's another adoption question, but this time pertaining to death certificates. If someone was legally adopted, do their adoptive parents' names go on the death certificate, or should you use the birth parents' names? So if you're paying attention to the answer I gave you with regard to final disposition, you probably already know the answer. The adoptive parents are now the legal parents of the individual, and their names should go on the death certificate. Does a registrar have a specific amount of time to issue a death certificate? They do. It's supposed to be within 72 hours after death. So neither the law nor EDRS policy or procedure specify a time frame for a registrar to issue a certificate. So then an issue meaning the same thing as asking for a certified copy. So if a funeral director is unable to get in touch with a registrar or it's taking longer than a week, the funeral director should contact EDRS at this email address, and they will help you with getting that taken care of. And that is courtesy of the folks of Vital Records. Even though they say EDRS here, it's really Dave, as we all know now. All right, moving from death certificates to a couple of questions on return of cremains. Is a funeral director responsible for ensuring an individual's intentions per the customer's designation of intention form is carried out when it comes to distributing, sharing cremains? You are not required to do that. You have to make sure that you are getting the cremains back to the person named in the designation of intention form. But once you do that, you have no responsibility for ensuring that the intentions of the decedent are then carried out. That is on the person who the cremains are returned to. Can a funeral director charge a refundable fee for storing cremains until picked up by the designated individual? You cannot. It's impermissible to charge a storage fee or a fee for disposing of cremains as indicated after 120 days have passed. Another scenario for you. A mom who has 4 children dies. All the children agree to cremation, 3 are local, 1 is not. So the 3 local kids sign to meet the majority requirement. Cremains are scheduled to be buried at the National Cemetery and to be done without involvement of a funeral home. The issue is who picks up the cremains. One sibling mentioned that a granddaughter wants a necklace from some of the ashes. Another does not want the cremains split up under any circumstances. The designation of intention forms is not filled out. The funeral director is waiting to fill it out until they know how to properly do it considering the circumstances. How should the funeral director proceed? According to the Bureau and the law, it's recommended that the designation of intentions be signed by the person who signed the itemization. The customer controls in most instances. But again, if there is a dispute, either majority rules or a court order is needed. Also remember that under the new law, we talked about majority. So if there were 3 or more people in the same priority list, like for example here, 4 children, so if there's 3 or more children, you need majority to move forward on final disposition. There's a list of the different, or a listing of the different categories where if you have 3 or more, that you have to get majority, and that is if there are 3 or more siblings, children, grandchildren, great-grandchildren, or nieces and nephews. Now, for example, great-grandchildren, if you get all the way down the list, this is only the case where great-grandchildren are the ones who are controlling disposition because there's nobody else remaining, and there happens to be 3 or more great-grandchildren. But those are the categories that you have to deal with the new majority rule. What options exist for a funeral director who wishes to dispose of unclaimed remains that date back to before implementation of the designation of intention form? So under 4204 of the health law, it's called disposing of them in a retrievable manner, which means placement in a tomb, mausoleum, crypt, niche in a columbarium, burial in a cemetery, or scattering of the remains at sea, or otherwise disposing as provided by rule of the department. In this scenario, scattering would not be permitted because that's not a retrievable matter. So you would be allowed to do the others that are. In addition, a record of disposition shall be made and kept by the person making the disposition, and after doing so, the person will be discharged from any legal obligation or liability in relation to such remains. And that actually is language from the law. That's your protection from taking care of it according to the law. Okay, another scenario. A funeral home has had the cremains of a woman since 2013. Her husband has been contacted several times and has not come to get them. He signed the designation of intentions, but this particular version was a shortened version and did not give the funeral home the right to do with them what they wish after 120 days. Yesterday, the daughter of the decedent called. She would like the remains mailed to her. The funeral home once again reached out to the spouse, who happens to be the stepfather of the daughter, with the number they had on file, and got the answering machine that gave them the name of someone else, although they did leave a message. So what can they legally do at this point? So 120 days have already passed. Since that already happened, you can still follow the new law or the law. So they could have disposed of them in any manner under the stuff we just talked about in the previous slide. You can also give the cremains to the daughter, but just to protect yourself, the funeral director should ask the daughter to make the request in writing, and the funeral director should write down that they tried reaching out to the husband, her stepfather, again after she had reached out. So this way there's just a record of it to help further protect them if ever called into question. All right, switching gears to funeral director duties. Can a funeral director pronounce a death? Yes, the funeral director can pronounce death, but you cannot certify a death. Pronouncement is limited to setting the time of death, so people like EMTs, police can also pronounce death. So long as you follow the prescribed tests, there is proof of good faith, so therefore you're protected from liability. And although you are allowed to pronounce a death, you cannot be compelled to do so. We know instances where hospice is going to try to require a funeral director to be available to pronounce death. They cannot compel you to do that, and you are not required to pronounce a death. Is a funeral director required to supervise the interment of cremated remains at a cemetery? You are not. Burial of ashes is not final disposition, as that took place at the crematory. No cemetery would ever be given a burial permit for this. So the basic rule of thumb that the Bureau gave us is any place you would need to produce or hand over a burial or transit permit is where a funeral director is required. Examples are cemetery for a burial, crematory for body delivery, or common carrier. Another scenario. A woman is on hospice and the family contacts the funeral director and says, we have a family cemetery on our property and we want a green burial. To them, this means the person dies, they dress her, put her in a shroud, and bury her. They know they need a funeral director to help file the death certificate. However, does the funeral director need to be involved with the body for any reason or to be at the family cemetery for burial? So the funeral director should be present at the actual burial. The footnote that the Bureau gave us is as far as the itemization statement. The funeral director should only charge for a direct burial where the family provides the alternative container, which in this case would just be the shroud. All right, we're going to switch over to some GPL questions, and for some reason, the last several months has been hot and heavy with GPL questions. When listing the direct cremation package price, does it have to include all mileage, or can the mileage be listed separately as per the regs? Does it matter if this is mileage for the removal or transporting to this crematory or cemetery? According to the Bureau, mileage is the only adjustment for the cremation package, which is that regulation. And if the firm uses one crematory regularly, it should be built into the package. If it's for the transfer of remains, it can be adjusted either based on the mileage, the GPL listed mileage charges, and also must be disclosed to the family. Health Regulation 79.4E has two quoted required disclosure statements, which do they have to be listed verbatim or can language be added? So that's under the additional services. Those are the two quoted statements that you have to include on your GPL. Yes, they must be verbatim under the law. You can't add to it, take away from it. But if you have additional disclosures which will inform the consumer about things, you can definitely include those. Just make sure that those two statements are listed as the law requires them or provides for them. Can a funeral home offer scattering services? And if so, should you or can you add it to your GPL? For example, renting a boat and going out on Lake Ontario near the lighthouse and scattering or placing a biodegradable urn into the water. You would not have the family present, but record the service and put it on a DVD or a flash drive. You are going to do this. you would actually list it under additional services and merchandise. The thumb driver DVD would be on the GPL as merchandise. As long as it's clear what you are offering as a service, there should not be an issue. Just a couple more, and we're almost done. Could or should a funeral home include a charge on their GPL for an additional director for a Saturday funeral? In this situation, the funeral director would be using a trade person to cover the funeral. According to the Bureau, in this situation where you're substituting one for another, a cash advance is the best way to go. Is a funeral firm allowed to add a weekend overtime charge to their GPL? According to the Bureau, there is no specific regulation or policy. They have generally allowed, quote unquote, reasonable charges for off-hours scheduled services. I put all caps because that's how it was presented to me, where the family has the option of choosing a lesser costly time. We do not allow overtime or off-hour charges for responding to the initial call for service as stated in the past. If both prices are on the GPL, can a funeral home have a different price for an online cremation arrangement where the person fills out the paperwork online and then they only sign the cremation authorization form in person, as opposed to if the person comes in for an in-person arrangement conference? Nope. The price on the GPL is for the firm, not the method of making arrangements. So same price regardless of the method. If a funeral home is working with the state of New York for a state contract and that's being done through a bidding or a request for proposal process, must the funeral home provide prices from their GPL, or can they provide better, more appealing prices? So the answer is you are allowed to offer alternative prices when working with the government. There's an exception in the health reg. The underlined, capitalized language I gave you the whole thing there. But the applicable wording is that it's not permitted to provide alternative pricing methods except for package prices which are agreed upon between the funeral home and a governmental agency. A consulting company calls a funeral home and asks if the GPL from 2006, which they have a copy of, is the most recent copy of their GPL. Does the funeral home need to provide a copy of their GPL to them? Not in this situation, because they're not asking about pricing. They're just asking if this is the most up-to-date GPL. So it doesn't provide a trigger about providing GPL because it's not about arrangements or price. Related question. A funeral home received a request for their general price list so that an organization can compile a price comparison with other funeral homes in the county. Do they have to share their GPL? Does the answer differ if the request is left on a voicemail or through an answering service? So under the funeral rule, under the guide, they say you have to give your price list to anyone who asks in person about funeral goods, services, prices, blah, 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 blah. So, and it also says in that last sentence, the request for information does not have to come from a consumer or someone who wants to make funeral arrangements now or in the future. So, if this request was made in person, yes. The fact that it was left on a voicemail or through an answering, it's not in person. So, under those circumstances, under the funeral rule, you have to answer the question that's about pricing, but you don't have to give them a copy of the GPL. That's totally up to you. So the only time you have to actually give a copy of your GPL is when the request is made in person, but you do have the requirement to answer the pricing questions that are posed to you via phone or mail. Again, how you answer that, by providing a GPL or just giving an answer, is up to you. Can a funeral firm have multiple fixed prices for removals listed on the GPL based on the number of people on the removal? So again, a long answer, but this goes back to the letter on the extra man removal charge as well. You are not allowed to have different prices based on the number of people. You can't have the extra man charge. That goes back to the package pricing that's required, and that package price has to include personnel. And the argument from the department is that if you started allowing for additional costs for extra personnel that was outside of the package price, it wouldn't truly give a comparison to the package price, and therefore is not allowed. Just two more. Should live streaming be listed on the GPL as an other merchandise item, or should it be incorporated as part of the arrangements? So live streaming, as you know, requires technical equipment and ability, and is not a standard part of a funeral or memorial service, so it should be listed as an additional service on the GPL, but it does need to be specific if regarding any limitations, such as only from the funeral home, chapel, or if there's a scale of prices depending on location or duration. So if you're going to charge different prices based on how long it is or where you're live streaming from, you should include those specifics. And our last question. A funeral home already has, not our last question, our last scenario, sorry. A funeral home already has custodial care listed on their GPL. The firm just added a refrigeration unit and would like to add it as a separately listed charge. Is this permissible? So the funeral home can charge for one or the other, but not both at the same time. The rule is that you cannot charge custodial care on any day the body would normally have been there and incur in charges already, such as the funeral service, visitation, and embalming, because those are separately charged items. Same goes for refrigeration. The body would have to be in the refrigerator incurring a charge, so it cannot be charged twice. And that concludes our Q&A for today. I'm sorry I went a couple of minutes over, but if anybody's still on and would like to ask questions, Kelly, we can start trying to help answer some of those.
Yeah, we do have several questions. So for those of you that need to get off, the time is up. You are welcome, but we will stay on until all questions are answered. Okay, question one. Here's a scenario question, so you might want to take notes. Funeral home A removes a body from a hospital. Unknown if duly authorized. Family changes their mind and authorizes funeral home B to pick up the deceased from funeral home A. Can the funeral home A impose a removal fee on funeral home B? If so, can they impose their retail charge? Please discuss this and if there is any recourse if the funeral home makes a removal and the family changes their mind.
I am almost positive we have had a circumstance similar to this asked of us in the past. I'm trying to rack my brain for the right answer. I believe, from what I recall, and I will have to look into our files to see if I have this in writing, is you are always entitled to be compensated for the services, especially in a situation like this where there's a change of mind. The funeral home B would need to alert the family of the circumstances, get the cost from funeral home A, and let the family know that there is a charge for that initial service. Now, whether the funeral home B wants to pass that along to the family or just absorb that charge because they're now handling the service is up to them. But funeral home A is entitled to be compensated, but funeral home B does not have to accept the case unless if they just wanted not to have to pay it, if they wanted to let the family know and let the family know. So funeral home A can charge B and let them know, and then B would work with the family to figure out what the cost was. Now, funeral home A did the removal based on assuming they were taking the case, so would have charged. I don't understand if there's I don't know the difference between a retail or other charge. I'm assuming there's just a removal charge on your GPL. So that would be the charge that you would pass along, saying you want to recoup for the services you provided.
Okay. A person lives in Monroe County and sets up an irrevocable account for their spouse. The spouse ends up in a nursing home in Florida. Is the overage to the account paid to the county in which they die if they have been in that nursing home for more than a year and a day?
So the interesting part, so the simple answer is the overage goes to the county where the decedent died or where they resided when they died. So in this case, it would be the Florida county. But now you're talking about outside of New York State, and Medicaid is a state law. So I am not sure if in that circumstance, those funds would go out of state to Florida, if that would be required under the law, or if that impacts the answer. That is something I would need to do some research on, because that one I'm not sure about. Although if there's another funeral director who's run into this in the past that can answer that and type it in for you, Kelly, that would be fine with me as well, because I don't know the answer because it's out of state.
Okay. I had an instance where the husband of a woman died suddenly before the divorce was final. Family checked with the attorney, who said as long as the divorce proceedings have begun, she does not have any authority. What are your thoughts on this?
Well, my thoughts are I would personally disagree with that. They are not final until they're final. They were not officially divorced, so when that person died, I would think that even though they started proceedings, other things like benefits, spousal benefits, they would still be entitled to. If this isn't a divorce attorney who is well versed in the law, then at that point I would say I need something from a court telling me that that is the case. Otherwise, we're still legally married when the spouse passed away. Therefore, the living spouse has rights to control disposition. That would be my answer.
If the underage mother can't control disposition of her baby, then who has the right?
So it's a good question. You'd start going down the list, and you'd probably go down and potentially get to a grandparent who might be that mother's parent. It's not going to be an agent. There's not going to be a spouse. There's probably not going to be a sibling. Although there could be, I guess, a sibling, but I don't know how that would work. I guess it depends on the father. So let's say the father is over 18, the father would be entitled because he's the biological parent. If not, you go down and then you get to like the mother's parents. So you have to kind of just work your way down the list. So I can't answer definitively. You'd have to, in the fact and circumstance of the family arrangements and who's over 18 and still around, willing and able, that's how you would have to kind of figure out who it would be in that case.
All right, we already answered that one. Can a guardian appoint an agent?
So a legal guardian is not the same as a power of attorney. So a legal guardian is not entitled to appoint an agent. They have the rights for disposition, but they don't have the rights to appoint agents, as far as I know. But that is actually an interesting. I'm thinking off the top. I'm thinking out loud now. I would like to confirm that one, so I'm going to do a little more checking on that one, and we will, as we have in the past, with any questions that remained unanswered for anyone who is registered and attended today's session, we will get that answered out in a subsequent email to everybody. But I need to double check that one because something inside me is saying they should be able to, but I want to confirm it.
Why are some hospitals not using Dave for fetal death? Some are still using paper certificate. Is that okay?
It shouldn't be okay. I mean, the way the law is written, everyone who has a responsibility for registering and filing for death certificates are required under the law to use the Dave system. So my recommendation would be let the folks at Dave know the name of the hospital and tell them that, and then they will reach out to them to make sure that they are using the system. Because my understanding is the way I know the law says it's required, so I don't know how they're not allowed, or they're allowed not to use it.
If a family member calls after the funeral for a death certificate, they were not the next of kin, even though they are entitled to one, are we obligated to get it for them, or should we send them to the city clerk directly?
You are not required to help them. I know that many, I should say, not most, but many funeral directors help the family members who are entitled out as a courtesy, but that is not a legal requirement, no.
Okay. Weren't domestic partners and final disposition agents granted authorization to receive a copy of the New York State death certificate recently?
I was actually looking. I can't remember if that was the law that changed last year or if that was one we were working on this year. I was actually looking that up right before the session and ran out of time. I will confirm that. Sorry.
When there are multiple children and they are the closest relatives, can one child sign the other than agent document and sign cremation authorization without other children's signatures?
The cremation authorization form, the way the Division of Cemeteries put it out was that as opposed to having, let's say there's 3 children, having 2 of the 3 sign at least, they have written it on their form in a way that says the person signing is acknowledging that they have the authority of the majority to sign on their behalf. So just one of the children would have to sign the cremation authorization form.
Can you show, sorry, go ahead.
I was going to say, did I answer that question, or was there another part to that I didn't answer? Or?
No, that was it.
Okay.
The slide that you have that discussed the monthly fee you can charge for an unpaid funeral, can you discuss that a little bit more?
Sure. Let me see if I don't know where that one, go back on. So you are allowed to charge a late fee for any unpaid balances. You have to decide what the length of time you're going to give somebody is to pay. Normally it's 30 days. So if someone is late in paying past the 30 days, in your contracts, you need to make sure that you are putting down that there will be a late fee and what the percentage is going to be. The law in New York State allows you to charge up to 25% per year. If you break that out, divide that out over 12 months, it equates to 2.08% per month. So many contracts, if you know you're buying something and you're going to pay later, it'll say any payment, any late fees, any payment that is not paid within X number of days after the due date or services are rendered is subject to a late fee of. So in this case, it can't be more than 2.08% per month. So again, your contract, your contract at the time, I would do it as of the date of service. So 30 days from the date of service, all payment is due in full. If it's not paid in full by then, the outstanding balance is subject to a late fee of 2% per month, for example. Hopefully that helped explain it, but if there's more, that person can, and still on the line, they can just type in that they need a more specific or question answered.
Great. Why do you know why some counties have central filing and some do not?
That I do not know. Each county can do things with some flexibility or latitude, is what we found out, and At the state level, there's not a lot of authority that they have over the counties. They're mostly independent, so there's not a lot of uniformity that they can impose. So we're not sure why. It's up to each county.
Can you define what package pricing in New York State is?
So on your GPL, you are required to include a package price for a direct cremation and a package price for a direct burial. And that package price has to have certain elements included in it. Let's see if I can go back and find that question real quick, because I don't remember them off all the top of my head. But basically, a package price is your direct cremation price that includes, so on this slide, you can see the second paragraph. Price of removal must be included in the price of a direct cremation or direct burial, as well as the price for floating remains, receiving remains. So those are some of the provisions that have to be included, or prices that have to be included in a direct cremation or direct burial package price. So there is a list within the law and the regs that include all of the different, at least these things have to be included. You add them all together, that's the package price. The package price can be discounted from each of those if they were done and chosen individually, but it can't be more. So for argument's sake, let's say all the pieces of your package price, if you were taking them from the GPL list, add up to $1,000. So the package price can be $1,000, it can be $900, but it can't be $1,100 or $1,200 because the package price is a way for consumers to not have to go and pick and choose. They're supposed to be able to have the option of just picking one thing that's going to get them everything they need if they want a direct cremation or a direct burial. But you can always discount that from your standard GPL price. I don't have the list in front. I don't have the reg up to show you all the lists, but if you go to Health Regulation 78.4, it'll show it to you. You can also just reach out to us here individually, and we can have email a copy to you of what the reg is. You can just send your email over to us or through the chat to Kelly.
I have an update about the death certificates from Steve. And Steve, if you're still on, I apologize. I accidentally answered you and not someone else. So regarding the domestic partner death certificates, that became law this January, but has not been implemented yet. Domestic partners and authorized agents getting death certificates. I was told the state is coming up with procedures for the registrar to verify domestic partnership.
Okay, great. I had a feeling when I couldn't find it on the legislative agenda, I remember it being discussed, and I apologize. I should have known that it was there, but it must have been because it hadn't been announced or put out there yet. So it must be, it must be in the procedural regulatory phase right now. So thank you for that answer. So I apologize. I have to update my slide because there's additional people that have to now have the authority.
Okay, I had a scenario where a mother and father and 2 young kids were all killed. The parents of the parents took care of their respective child, but there was a lot of fighting over the grandchildren. In New York, is there any guidance to that, or would it automatically go to court?
I'm sorry. Can you just can you just say that one again?
So, a mother and father and 2 young kids were all killed.
Okay.
The parents of the respective adults, the mom and dad, took care of their children. But then there was a lot of fighting over the grandchildren. In New York, is there any guidance to that, or would it automatically have to go to court?
I guess I'm not sure, is the question related to?
So
has
I think the question is
custody
related
now, or
to,
is it something?
so as far as because the children were killed. So as far as
Right.
who has authority, there's 4 individuals, both sets of grandparents that have the same right
I'm
to
sorry.
decide
Okay.
what to do with the grandchildren.
Okay. So let's see, grandparents are not amongst the list. So yes, I would say that if the 4 grandparents cannot agree and they're the ones who are in control, that I would pause, and if they can't come to an agreement, have a court direct how it should go. I agree with that. Yes. I apologize. I couldn't follow that scenario.
it was difficult, yes. Okay, does Medicaid have the right to know what the itemization of an irrevocable pre-need customer has chosen?
I don't know. It doesn't say anything in the law that I saw that says they have a right to see it. I'm sure if they wanted to see it, they could ask for it. My understanding is that they don't know, they don't ask, they don't know who has an irrevocable, so it's kind of the honor system as far as when you remit the overages to them.
Okay. And this might be the last question. We'll see. If one of 4 children claim to be the executor of the deceased, do they have the right to control over the others, or should we follow the hierarchy order?
Ooh, that's a good question, and I should have mentioned this during my presentation. So, I mentioned POAs not having any rights. An executor in a will is not listed anywhere on the hierarchy. They have no rights above anybody else. So, the only time an executor has the right to control disposition is if the will is the written instrument that uses basically the same language as the agent form, where it's very specific and states, I designate my executor to control my final disposition, control my funeral service, make decisions about. It can't say to pay my just funeral expenses, which is what most wills default to. So if there's wording in the will very specifically designating the executor to be the person who they want to control disposition, that can substitute for the agent form. If it doesn't have that language, then the executor is just the executor as it relates to the estate, nothing to do with final disposition. And as you said, you then go to 3 of the 4 children would need to agree as to final disposition under the new majority rule, and you'd go that route.
Well, I was wrong. There is another question. All right. Sorry. A funeral director or person can pronounce but not certify the death certificate. In the scenario of an at-night hospice home death, where hospice doesn't show up to pronounce, I think we've had this before. If the hospice doesn't show up to pronounce until after midnight, not only would the time of death be different, but in the family's mind, sitting bedside, the date of death would be a day later. How can this be indicated correctly on the death certificate? I can't remember what the answer was. I know we came up to this because it had to do with the family date, that it meant something, that the person died on the date they did, but it was just before midnight. And I'm almost thinking there was nothing that could be done.
Correct.
That's what's coming to my mind.
Yeah, I think it was like the family could try to argue that they were there and the person died, but until you have a pronouncement that is then later certified, there is no way for anyone to be able to rely on that. And only certain people can pronounce. So if no one showed up, then there's nothing they can do. I mean, the only thing they could possibly do is bring some kind of court proceeding or something that they would try to go to surrogate's court or somewhere and try to say, this is the date and these are the facts I have to support that, this person died this time, this day, as opposed to what's being said on the pronouncement. But you're right. Unfortunately, there was nothing. I think it had something to do with either a birthday or something. It was very important for some reason in terms of what was put on the death certificate. But there was nothing that could be done barring some type of legal intervention.
Right. All right, that is it. That is finally it. Oh, hang on one second. Okay, this is regarding the executor having power, and a funeral director said, but the executor would only be empowered as quasi-agent after the will has been submitted to probate and letters of testimony.
Yeah, the will, if the will goes into probate, then they could request that aspect of it is certified or approved so that they could move on with the funeral services, because it doesn't have to deal with the distribution of the estate. However, you're right. It's just, a funeral director relying on that language in a will, knowing nothing else is contested, I don't think if you acted, that would still be reasonable to act because of the timeliness of what you have to do versus the probate. But I can understand the point for sure.
Well, I want to thank everyone for attending this webinar, as it's always interesting and we always learn a lot, I feel. So yeah, if you have any questions, you know how to reach us. Give Mike or I a call and we will check into the few things we weren't sure about and get back to you on that. And I hope everyone has a great afternoon. Thank you.